We have two cases on the docket today. The first one being Mosley versus Rebecca Beller as personal representative. Is the appellant ready to proceed?
Yes, sir.
You may.
Your Honor, if I could reserve 5 minutes for rebuttal. Thank you, Your Honor. Daniel Mafood of Creed and Gowdy on behalf of the appellant. May it please the court. Our jury system cannot function when jurors fail to give truthful and complete answers during voir dire. We're here today because two jurors, Gary Jones and Brian Smith, failed to do so. At the beginning of the trial, counsel stood before the panel of 23 prospective jurors and asked each and every one whether they or a loved one had ever been involved in a car accident. In response to these questions, Mr. Jones failed to disclose that he was cited for careless driving after sideswiping and damaging another vehicle on May 17, 2012. Mr. Smith, meanwhile, sat virtually silent during the entire voir dire, but it was later discovered that he was involved in 3 separate crashes, one as recent as 13 months before jury selection. This court's precedent is clear. Where there are reasonable grounds to believe concealment of a material fact has taken place, a party is entitled to conduct a jury interview. Here, the undisputed fact that 2 jurors were involved in car accidents that they failed to disclose during voir dire, despite careful, repeated questioning, creates reasonable grounds to believe concealment of a material fact has taken place. The trial court thus abused its discretion in refusing to permit counsel to interview those jurors.
So the test is laid out in De La Rosa, correct?
Well, Your Honor, that's the test for a new trial.
Okay.
And when you're evaluating a request for jury interviews, you have an eye towards what the standard would ultimately be for a new trial, but of course, you can't be required to satisfy that standard when you're seeking jury interviews, or else what would be the point of doing the interview? You'd already be entitled to a new trial. And so I think the better question to ask is the way this court put it in Singletary, which is whether there are reasonable grounds to believe concealment of a material fact has taken place.
Okay, well, let's talk about Juror Smith.
Sure.
The first accident that he didn't disclose was one that his car was involved, but he wasn't driving.
Well, Your Honor, I think if you ask someone whether they were involved in an accident and my car was in an accident, and now I have damage to my car and potential insurance claims, and my loved one may be in the car as well.
So what was asked?
The question was
Because if you asked me if I was involved in an accident, that would be, was I involved in an accident, not someone I know was driving my car and was in an accident.
Well, Your Honor, the question was actually whether they or a loved one was involved in an accident. And so without a juror interview, we simply don't know whether Eric Wally, who was the driver in the car, was considered a loved one by Mr. Smith. And in Mr. Smith's case, during the entire...
Do we have any reason to believe that Mr. Wally was a loved one and he didn't give that information?
Well, Your Honor, at this point, we can only speculate. We don't have any specific evidence that he was, but we have no reason to doubt it either. And certainly there's a reasonable possibility that the person he entrusted to drive his car may have
Might not have been a loved one after he crashed the car, right?
Pardon, what was that?
I said he might not have been a loved one
Right,
after
less
he
so
crashed
after the
car.
crash, right? Although, in fairness, it wasn't his fault. So the question...
So the other one, he was hit by a deer.
Right, or he hit a deer. You could phrase it
Okay.
either way, I guess.
Well, it could have been either way, right?
That's true.
Sometimes you hit the deer, sometimes the deer hits you.
Correct, Your Honor.
Okay. Well, I mean, most people when they think of a traffic accident, they think, that involves another car. You're in a personal injury trial and you think that this kind of thing, another accident like this, not wildlife.
Your Honor, I understand that reasoning. What's important here, I think, is that the standard is whether there's a reasonable possibility that there was material information. So, as was pointed out
looking
earlier...
at the La Rosa test, how would a potential juror hitting a deer be a material issue in this underlying case?
Well, Your Honor, for Mr. Smith, I think there's 2 issues. One is the more recent accident, which was noted at the scene that there were personal injuries. The deer, that's less obviously relevant, but now we're talking about multiple accidents that he failed to disclose. And I think Mr. Smith said 2 words during the entire voir dire when he was asked what he'd rather be doing. He said anything outdoors. The idea that he sat through the entire voir dire and said 2 words when he has 3 accidents, I think calls into question whether he was genuinely participating and fit to serve as a juror. I think also when you look at the answers the other jurors gave, they disclosed all kinds of accidents,
In
including single
reference
car
to the
accidents.
July 1996 accident, how would an accident that occurred 21 years prior to the jury selection at issue be material in this case?
Your Honor, if that were the only accident, I think we wouldn't assert there's an argument there. But I think in combination with the other two, one as recent as 13 months, as I said, it's hard to look at that and understand what was going on there without the opportunity to ask Mr. Smith what was going on. And I think, again, the standard is reasonable possibility. We're not trying to get a new trial right now. We're just trying to ask the jurors what was going on.
Yeah. Well, I mean, you know, the way I read this, it sounds like, you know, that there was only one accident that was actually responsive to the question. And that's the one that involved another car, and that was pretty remote in time. I mean, you know, I could see how someone might not remember that.
Well, Your Honor, I think if you look at what the other jurors disclosed, they weren't kind of putting a lot of thought into what do I really think counsel is getting at. They just asked the question that was, answered the question that was asked, which was, were you or a loved one ever in your life involved in a car accident? So
Yeah.
other jurors disclosed accidents that were far more remote in time, or just as remote in time,
Yeah.
that involved only one car that resulted in no injuries. And it was clear during the course of the voir dire that counsel appreciated that we wanted all the information they could give us. And so in Mr. Smith's case, I don't think it's reasonable that he wouldn't have disclosed them, even if arguably he could have reasoned, well, this doesn't seem that important. And then I'd also like to...
But I mean, in your typical jury selection, there are some jurors that just want to talk, and then there are some jurors that are reticent, and you've got to ask specific questions to them to get any information out of them. That's just the nature of having a group of people sitting all together that don't know each other.
That's true, Your Honor. And reticence is one thing, but being directly asked if you've ever been involved in a car accident or a loved one, and to have 3 in your record that we can find that and not mention anything, I think goes beyond reticence. He said 2 words during the entire voir dire, so I think it's worth asking him what was going on, if he was really participating, and if, you know, maybe your explanations are exactly what he'd say, but at this point, we simply don't know.
But again, counsel, going back to the July 2016 accident, isn't it true that an appellant can't definitely say that Gerald Smith failed to disclose the 2016 accident, given that appellant's counsel did not ask whether the jurors owned a vehicle that was involved in an accident?
Well, Your Honor, so it's true that at this point we can't say, well, sorry, Your Honor, I would say that if my car was in an accident, I would feel involved in the accident. That's my impression. And then I think also we don't know whether Mr. Wally, the driver, was a loved one of Mr. Smith. And, you know, that there's a reasonable possibility there. I don't know how many people you loan your cars to, but if you ask whether it's reasonably possible that the people who are driving your cars are loved ones of yours, I think the answer would be yes. And then I'd also like to point the court towards Mr. Jones, and I think his case is particularly, there's a good comparison between him and Mr. Soy. So Mr. Soy was a prospective juror who was struck after he disclosed, and this is all he said during the voir dire, that he was involved in a minor accident where the other car bumped his back tire. He admitted that he was at fault. He immediately said no one was hurt. There's no evidence that there were any lawsuits or claims that arose from it. And he said, you know, I don't have a bad taste in my mouth. It won't affect the way I judge anyone else. And yet, counsel chose to strike Mr. Soy.
But counsel, if appellant did not seek to strike Juror Jones after being told about one of his car accidents, how would him having disclosed his side-swiping accident have changed appellant's decision not to move to strike him?
Well, Your Honor, so many jurors disclose car accidents, and so the first thing you have to realize is that it's very fact-specific. Counsel is trying to figure out the nature of these accidents. One thing that counsel asked of every juror who disclosed an accident was, will that affect how you view this case? How do you feel about it? Well, we didn't get to ask Mr. Jones that about the accident he didn't disclose. I think the other big distinguishing factor is that the accident he disclosed was a single car accident, so there was no possibility of someone coming to him with a claim for payment or suggesting that he did something wrong. In the accident he didn't disclose, he was cited for careless driving and damaged another vehicle. And so that creates more than a reasonable possibility that someone came to him seeking payment for the damage he caused, and having been accused in that way, he would
So that's the
identify
one where the
more-
mirrors hit each other.
Yes, yeah. Well, he damaged the mirror of a parked car, that's right.
And the estimate in the, I guess it was the police report, was that $100 worth of damage to Mr. Jones's vehicle, and maybe $200 to the Florida Pest Control.
Yes, Your Honor, and in as much as he was driving his employer's car, he may have been at fault with respect to his own car as well. I don't know that so when you look at Mr. Soy's accident, he said it was very minor. He said the other car just tapped his back wheel. We don't have any reason to believe there was a significant claim there. And yet we have the undisputed fact that plaintiff's counsel decided to strike Mr. Soy. And so when you're trying to put yourself in plaintiff's counsel's shoes and ask yourself whether the information that wasn't disclosed may have influenced counsel to use a strike, I don't think there's any way you can compare Mr. Soy and Mr. Jones and not think, there's just as much reason for one as the other. So I think the fact that although Mr. Jones disclosed an accident where he wasn't at fault with respect to any other driver, here we have a case where he was in the same position the defendant was in. He was in the position of being accused for being a careless driver and asking, well, how much do I owe you now? And having been in that frame of mind, I think it's safe to say that he might be more sympathetic to the defendant in this case. Your Honor, I see that I'm into my rebuttal time.
Thank you.
May it please the court, my name is Rhonda Bogus, and I represent the defendant who is now the appellee, Rebecca Beller, as personal representative for Mr. Robbins. I want to begin with the discussion of the fact that this is an appeal of a request for a jury interview, which should be rarely granted. It is violating the jurors' rights, and court cases have basically said it's something that should be done only in the rarest of circumstances, and it's under the discretion of the trial judge. The trial judge is the one, because it's on abuse of discretion standard before this court, the trial judge is the one who has seen the dynamics of the jury process, is able to see the questioning, is able to see how the people are responding, and the case law basically says that the trial judge is in the best position to make that decision. And like a denial of a motion for new trial, the fact that this trial judge did an order that said deny doesn't mean anything. The trial judge heard argument. The trial judge said, I'm going to review the documents that you've provided, which, by the way, were just documents. There was no affidavit, no testimony. I'm going to review them. It's going to take me a couple of hours.
So with Juror Smith, there were 3 accidents that weren't disclosed. Why was it not abuse of discretion for the judge not to grant it in this case, where it seemed like there was no disclosure of any material of several accidents by Juror Smith, and not even downplaying it or listed a number of accidents and forgot one,
Right. Well, I do disagree a little bit with the Singletary. Singletary, that's the only issue. Look, is there anything that we can speculate? You kept hearing answers. Well, we could speculate, but we'd like to ask them. That's not the standard. There needs to be some evidence that De La Rosa test would be almost a prima facie on the face that if all these things were proven true, if this was the juror involved in these accidents in this case, would it meet the De La Rosa test? And like in the Garrett case, in this case, this is a non-liability. Negligence was admitted. It was a rear-end accident. The only thing that was at issue was causation and damages. And in fact, the plaintiff's counsel started the jury discussion by saying, and I'll do the quote so I don't misquote it, basically was telling the jury that this is a personal injury case and that the purpose of the process was to find out if you may have had a life experience in which you had a personal injury case or had someone you care about in a personal injury case. Well, there was no evidence that there was ever a personal injury case. Nobody failed to disclose litigation. So with Mr. Smith, okay, you've got the 3. You've got the owner of a vehicle. I would disagree that the accident report indicates that there really were necessary damages. 3 of them were none. 1 of them was possible. Any event, there's no evidence that there was any litigation. And just like in the Garrett case they were talking about, the mere fact you're in an auto accident, well, let's say 16 of these jurors responded that they'd been in an auto accident. Does not mean that it's...
Even if we agree that hitting a deer, an accident that occurred 21 years ago, may not be material to the jury selection at issue in this case, why shouldn't the appellant be allowed to interview Juror Smith about the 2016 accident that his car was involved in?
In that accident, the only basis we know, there's no evidence of a litigation, so we don't have a situation where there was a litigation. It's a situation in which, if anything, there would just be vicarious liability. Well, my liability is not an issue. It's not material. And in the Garrett decision, the 50CA was talking about, when you have a jury selection process where the focus of the person who's seeking the interview is to deal with personal injuries and continuing pain and attitudes towards people that have been where you've been the subject of a claim for personal injury, you know, some of those things that could be material. There's no evidence here that there was any claim ever made. There's no evidence there's this accident. There's nothing really there. He kept saying that it was concealed. I don't even think it was concealed. The actual question from the jury to the jury was, has anyone here been in, or someone that they care for or love, been in a motor vehicle crash before? You know, he said we can speculate that maybe he knew this person, maybe they were a loved one, but we don't speculate for jury interviews. So you're talking about just a crash with no accident. There's no indication that there's anything more than that. And in fact, when you look at, they talked about Juror Soy, but Juror Soy, he was the one who said he had been ticketed and he had a bad feeling, a bad taste about it, but okay, if it's my fault, I guess it is. That's an attitude issue. That's not the same as you just happen to be the owner of a car, that you were not in the motor vehicle crash. You have to have more than that.
But don't we depend on jurors to answer these questions correctly and truthfully, so we can see if there's an attitude? And that's the whole point, is to see what their attitudes are to this litigation we're sitting in.
It is, and those questions were asked of the jurors as to whether there was anything that they should share. But there was not a specific question. For it to be a concealment, it needs to be squarely asked, and you need to have an answer that is incorrect. And there was no question of any juror or any follow-up that says, did you ever have a vehicle that was in an accident that you were not involved in? I mean, the question was, were you or your loved one involved in an accident? And the other issue in terms of materiality is there's no indication that this plaintiff's attorney was really interested in just auto accidents. There were 16. He was interested in people relating to pain and things like that. So there's no indication that it was actually material in any way. So all we have is a accident report from buy-in crash, no affidavit, no nothing. And to bring that juror in when the questions were all directed toward personal injury cases. And again, if this was a case where there had been litigation arising out of him due to vicarious liability, I'd have a tougher argument here, because then you would have a defendant, but we don't have that evidence. And to have the juror come in and to be questioned regarding a motor vehicle accident that didn't result in litigation, he did not raise his hand for any litigation, and there's no...
Counsel, how could the appellant prove materiality in this case without interviewing the two jurors at issue?
What you have to do, in my opinion, in determining whether to do a jury interview, you have to look at the material that has been provided, the evidence, and in this case you could argue whether there's even evidence, but the sworn evidence, the evidence that's been provided, assume it's correct, and say, if you assume this is correct, would this have been relevant and material? I would argue it would not have been, based on his discussions on minor accidents. There are plenty of people with auto accidents that were on this jury. That was not the concern of the plaintiff's attorney. It has to be that there was a direct question asked and that the juror did not respond appropriately. I think that's lacking here as well. There is no evidence that there was a loved one or you were in a motor vehicle crash, and that's actually the question. And then you have to show that this information did not come out due to failure of plaintiff's counsel to ask diligent questions. And in that sense, it's also true that when you look at the process as a whole, what was going on was that he wasn't really interested in an accident. I mean, there were people that were in there that had even caused accidents or had single car accidents. He was interested in the litigation, in the personal injury, in pain, and things like that. And they just have not met the, even if you assume it's true, the De La Rosa test cannot be met in this case. And therefore, since they don't make that De La Rosa prima facie, assuming that everything is accurate, that should be it. And in fact, the Singletary case was talking about reasonable grounds. This court has held that Mailer talks about actually sworn evidence. But in this case, you've just got a couple of auto accident reports with no indication, no litigation. Again, it's not litigation, no indication of anything other than there was some accident that a car was involved in. And that would really, if you can't meet the De La Rosa test, if you assume it's accurate, it's going to be a situation where you have a fishing expedition, and that is exactly what we are supposed to avoid. And I think the trial judge, who was in the process, who was watching, he was seeing how they were interacting, he was seeing the follow-up questions, he was familiar with what the peremptories. One peremptory was on somebody who had a problem with excessive verdicts. One of them was someone who had expressed dissatisfaction with being cited for an accident, and the other one, let me see if I remember that, was he actually had said that he got concerned when he said cited and someone claimed damages, which he refers weren't warranted. So two of these people were situations where they had been cited. Where's it? We keep talking about the 2016 accident. Mr. Smith was not cited. That was the concern of the plaintiff's counsel, who had a defendant who was legally liable, and they didn't want people on the jury that would have been sympathetic to somebody being legally liable, whereas Mr. Soy said, well, if they had just tapped the brakes, it wouldn't have happened. So the plaintiff's attorney, for good reason, was not wanting people that think that people may be legally liable, but they really shouldn't be, because all somebody had to do was take another action. So two of the three people were people that had been cited, were not happy about that, and expressed, disagreement. So even if Mr. Smith had stood up there and said, yeah, I think I had a car that was involved in an accident where you cited, no, I wasn't even the accident, that would have been it. I think when you read the jury process as a whole, and the trial judge was in that position, and the trial judge made the decision that, no, this is a way of getting out of a defense verdict. It's not a true concern of the plaintiff's counsel. It was not what this case was about. We're not dealing with vicarious liability. The only thing we were looking on for people that feel like that they are unfairly liable, and somebody who isn't willing to.
Will you talk about diligence a little bit? I know the trial court did.
Well, that's interesting. The trial judge did in the hearing talk about why didn't you ask do this search during the trial. And the Supreme Court has held in Roberts that you are not required to do that. But there's been at least one or two cases that say, and I'm going to see if I can find that exact case, that says that doesn't mean it's not a factor. Because it goes into play as to really how important this was and whether it was something that you really were concerned about. And so the fact that the judge actually asked questions about that doesn't mean that it was an abuse of discretion. The courts have held that you actually can, take that into account. And the other thing is that this judge was also, I think, a little concerned about whether there was evidence. There was no affidavit. The plaintiff's counsel said, well, where'd you get this stuff? And he said, well, investigator pulled it. Was the investigator here? No, the investigator's not here. There wasn't an affidavit. Originally, they'd said it was from public records, but it was like, what's this buycrash.com or something like that. So there was some concerns a little bit about that as well. But what we do know is after those arguments, and the trial judge acknowledged, I'm not saying you have to do it. I'm just it just goes to the fact that they really weren't interested about auto accidents that weren't litigation, or auto accidents in which a juror had not been cited. The judge made a point of saying, I've got a couple of hours because I've got to read all this appendix, and I've got to read. He was given the transcript, I think he was given the transcript. I know he was given the accident reports in detail. And those, sometimes take some time to go through and read the details on it. And so he did his due diligence. He exercised his discretion. And in all due respect, I do believe that this is one where the trial judge did not abuse his discretion. Reasonable people would not disagree as to what he did. And he was the best person to make that determination and did so. For that reason, we request that you affirm. Thank you.
Thank you.
May it please the court. Your Honor, the bottom line in this case is that we need jurors to give truthful and complete answers during voir dire. That's the only way the jury system works. And while it's true that we don't want to constantly be haranguing jurors with lots of questions, the Supreme Court explained that while we do not encourage concepts that lead unnecessarily to repetitive proceedings, we must never fear reconsideration when the integrity of the jury process itself is subject to serious question. So I think we've come and shown that undisputedly jurors fail to answer the questions truthfully and completely. That's the reason why we're doing this. It's not because counsel wants a second shot or we're doing a fishing expedition. The fact is we need the jurors to be honest and truthful and complete, and we have evidence, we have the crash reports that show that they weren't. I think the second thing I want to talk about really quickly is we have to get the standard correct. My friend on the other side has kind of talked about different standards at different times, but in her brief, she says, only when the movement has set forth adequate proof that a juror may have failed to disclose material information is a party entitled to conduct a juror interview. That's very similar to what this court said in Singletary. We're not trying to prove that a new trial has to be granted. We're trying to say that we have some information here that suggests that there might be some material information that we need to look into. That's what we're after here.
So what would you ask if you were granted the interview?
Well, I think we would.
Let's say you've got the two jurors, you brought them back in, and you say, okay, you didn't tell us about these 3 prior accidents. Why not? Is that going to be the question?
I think that would be one of the questions. I think what you see every time a juror disclosed a crash in the voir dire, one of the things counsel always asked was, how do you feel about it? Is this going to affect the way you look at this case? And even if a juror didn't remember
So
during
do you do a whole nother voir dire of those 2 venire persons? You say, why didn't you disclose it, and how do you feel about that? Tell me a little bit about how extensive this interview is going to be, if we rule in your favor.
I think, Your Honor, it would be very similar to what counsel did with each of the other jurors who disclosed the crash. We need to be able to do the same. You know, the other side calls it a fishing expedition, but that's kind of what voir dire is. You're throwing questions out there, and they give you an answer, and you kind of probe it. And that's what we would do with these jurors. We certainly wouldn't. So in Mr. Smith's case, we don't have to ask him again what he'd rather be doing because we already got that answer. We won't rehash old things, but we're going to go into, look, we asked you if you were in an accident. We found out that you're involved in 3. Can you tell us about that? How do you feel about it? Were there any claims? Did you find out about any injuries?
Well, you know there's no litigation, right?
Well, I don't think we know that for sure.
Well, hold on. You've not made the assertion that there was any litigation that was not revealed, right?
Your Honor, I think our assertion is that the fact that there was the crash creates a possibility. We certainly haven't.
Didn't you check for that? I mean, that's easily
Your Honor,
obtainable from public records of the state of Florida, right?
I'm not 100% sure whether everything is available, and certainly it wouldn't be available.
I'm just kind of curious. What is this interview going to accomplish?
I think in both cases we'll find out what the jurors' impressions were. When you look at Mr. Soy, he said, it's not going to affect the way I judge anyone, but he did kind of, he's said he had some equivocation about, I wish they would have just handled it differently. And that was
But
enough.
again, that goes to, and your opposing counsel's made the point that the litigation status was not at issue. Let's take best case scenario in a light most favorable to you. You're going to ask the venire person, okay, you didn't disclose this accident with this person who may or may not have been a loved one, right?
Right, we'll find out if he's a loved one.
Well, okay, we'll find out if he's a loved one. Number 2, you're going to say you had a collision with a deer, right? Mm-hmm. How do you feel about that, or?
Were there any
I don't mean to be
injuries?
flippant, but you're not going to say, did you sue the deer? Would you
Certainly
say, did you file a claim against your insurance company for damages, or?
Perhaps what his estimation of the damage was given his accident. He could easily said, I hit a deer once. I was going this amount of speed. Nothing really
But your
happened in my
opposing
case.
counsel notes, and I was contemplating this, that liability is not at issue.
With the deer, Your Honor?
No, well,
Oh, sorry.
in this case.
Correct, but what we're asking...
This strictly was a case on damages, personal injury damage.
What we're asking is someone who is at fault, how much do they need to pay? And if I have some sense of what the damage should be because I was
What
in an
about the
accident-
other juror? I'm taking up more of your time now, but what about the other juror?
Juror Jones?
Right.
Well, I think Jones is a very compelling case when you compare him to Mr. Soy. Repeatedly throughout her briefing, the other side has said that we only care about personal injuries. We only care about lawsuits. There was no indication of any of that with Mr. Soy, and yet we still decided to use a peremptory strike on him. I don't think you can compare him to Mr. Jones and come up with any really persuasive reason why we wouldn't have done the same thing with Mr. Jones had we known. And certainly there's a possibility we would have, and I think that's all we need to show, Your Honors.
All right.
Thank you.
Thank you. Thank you both for your arguments. We'll allow counsel a few minutes to disembark and then call the next case.